Hello everyone, welcome to Court with Krissy. Time for a couple of updates. One gets better and one gets worse. Mr. Dziuba again is a no-show. Last time it was COVID, the ice storm, and a flat tire. What is it this time? You will have to watch and find out. But thanks to Big Tiff Dog, she shared some info. I've dropped those details in the video. As always, if you happen to miss the first appearance, link is in the video as well as in the description. I hope you like it. Court with Krissy is now in session.
Mr. Seeger, how do you think we should proceed in light of the background of this case or going forward?
Your Honor, just to give you, and not that the court isn't generally aware of the background, but as the court is aware, we have previously attempted to enter into a plea. The court did at one point in time review the police report such that it was unable to create a factual basis to support the charge. In further discussions with Mr. Toby, and to his credit, I think he maybe somewhat misunderstood a potential theory of the law. And so I do understand why the court might construe it as him being obstinate in terms of accepting a plea. But in further discussions with him and further trying to explain some legal theories, it's my understanding that he wishes to accept a plea. That plea would be to one count of felonious assault, which would be treated under HIDA. And so it's my understanding that he wishes to plea. Yeah.
Is that an accurate statement of plea offer that the prosecutor's office is suggesting a sentence under HIDA for one count of felonious assault?
That's correct, Your Honor.
And how old was Mr. Toby on the date of the offense, Mr. Seeger?
I don't know how old he was, Your Honor, but I know he was under 21.
It would have been 18 or 19. Your Honor.
So it's not necessary that there's consent from the prosecutor's office, but nonetheless you are consenting.
Correct.
So that would be count 3, correct? Assault with a dangerous weapon.
Yes, Your Honor.
Dismissal of all else.
Correct.
Mr. Toby, did you hear the terms of that plea agreement?
The felonious assault?
That's right.
Yes.
You understand the terms.
Yes, sir.
There's been a lot of what I would view as misunderstanding in this case. Do you fully understand what you're offering to do today and how you're able to accomplish it?
Yes.
Raise your right hand, please. You solemnly swear, other right, please. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Mr. Toby, this plea agreement calls for you pleading guilty to the offense known as assault with a dangerous weapon, otherwise known as felonious assault. Are you aware of that?
Yes.
That is a felony offense with a maximum punishment of 4 years in the state prison system and or a $2,000 maximum fine. Are you aware of that?
Yeah.
Is there a question in your mind about those maximum penalties?
No.
The statute also allows and requires, in fact, that DNA must be taken upon your arrest. If it was not taken upon your arrest, that it's taken after this plea. You understand that?
Yes.
The benefit of the plea agreement is that if you plead guilty to count 3, the felonious assault conviction, felonious assault charge, the prosecutor dismissed count 1, count 2, count 4, and count 5. You understand the benefits of the plea agreement?
Yes.
The further benefit is that the attorneys are going to be asking me to sentence you under what's called the Holmes Youthful Trainee Act status. Are you aware of that?
Sorry, it's kind of hard. Can you repeat that?
That's all right, I'll speak up. So the attorneys are also suggesting that under this plea agreement, I should sentence you under what's called the Holmes Youthful Trainee Act. Are you aware of that?
Yeah.
Holmes Youthful Trainee Act would be a deferred sentence. In other words, if I granted that status, you would be put on probation, subject to various terms and conditions, including the full payment of fines, costs, and restitution. If at the end of that probation you were successful in meeting all of those terms, this conviction would remain what we call non-public. It would be as if you did not have a conviction. Do you understand that?
Yes, sir.
On the other hand, if I put you on probation under HIDA and then you violated any term of probation, failed to pay fines and costs, I could immediately revoke that status. And if I revoked that status after sentencing, you would have the matter on your record and you would be subject to the maximums that I've already described. Do you understand that?
Yes, sir.
HIDA is solely up to the court's discretion, meaning while I will certainly take into account the attorney's views, their arguments, and their suggestions that I sentence you under that, it's ultimately totally up to me. Do you understand?
Yes.
But because it's such an important part of your plea agreement, if I decide to not grant HIDA sentencing, I would give you the opportunity to take away or withdraw your plea. Do you understand that?
Yes.
understanding all of the benefits to the plea agreement as well as the maximum penalty you could face for felonious assault, how do you plead then to the crime of felonious assault?
Sorry,
How do you plead, understanding the benefits of the plea agreement, understanding the maximums that you could face for felonious assault? How do you plead to the offense of felonious assault?
attending in the assault, knowing that he had the weapon.
The question is how you plead. That plea would be either not guilty by reason of insanity, guilty but mentally ill, or no contest. So how do you plead to the offense of felonious assault? Mr.
Guilty.
Toby, this process is not difficult. It hasn't been difficult any of the many times that we've been in court. My sense, once again, is that you are intentionally frustrating this process. I recognize I could be wrong in that estimation, but this is a plea agreement where you're offering to plead guilty. So when I ask the question what your intention is and how do you plead, it should be fairly obvious to you if you understand. So let's back up. Do you understand?
Yes, sir.
How do you plead to the offense of assault with a dangerous weapon, otherwise known as felonious assault?
Guilty.
If you plead guilty, you no longer have any automatic right to appeal. Instead, you would have to ask the Court of Appeals for leave to appeal. Do you understand that?
Oh, yeah.
Do you want me to explain that more fully?
If you would like to, yes.
It's not about what I'd like. I want to make sure you understand. If you're convicted at trial, you have an automatic right to appeal. However, if you plead guilty, as you're offering to today, your appeal rights are limited. You would have to ask the Court of Appeals for leave to appeal, which they could deny. Do you understand that now?
Yeah, I do understand that now.
If you plead guilty, you lose all of your trial rights. Those trial rights include the right to be tried by a jury of your peers, the right to be presumed innocent until you're proven guilty, and the right to have the prosecutor bear the burden of proving your guilt beyond a reasonable doubt. At your trial, you would have a right to have the witnesses against you appear and to see, hear, and question those witnesses. And you would have the right to have the court order any witness on your behalf to be ordered to appear at trial. You would have a right to remain silent during your trial and not have that silence used against you. And you would have the right to testify at trial if you wanted to. But if you plead guilty, those trial rights are gone. Do you understand that?
Yes.
You have questions about that, Mr. Toby?
No.
If you plead guilty, you also necessarily give up the right to challenge other things that you might have been able to challenge if you did have a trial. Do you understand that?
No, I didn't, but now I do.
Outside of the plea agreement, has anyone promised you anything to get you to plead guilty?
No.
Has anyone threatened you in any way to make you feel like you have to plead guilty?
No.
Are you pleading guilty freely and voluntarily?
Yeah.
Is it your choice to plead guilty?
Yeah.
Mr. Toby, you need to understand that if I accept a plea from you, and then in between the date of your plea that I accept and your sentencing, you commit any form of misconduct, then the opportunity for you to be sentenced under HIDA is not guaranteed, and it is not a basis for plea withdrawal if you commit misconduct in between the plea date and the sentencing date. Do you understand that?
Yes.
Turning to the offense, the prosecutor claims that this offense happened on November 6th of 2024. Do you think that date's accurate?
Yeah.
On that date, were you present here in Kalkaska County?
Yes.
What did you do that makes you think you're guilty?
I assisted in the assault by punching the victim, knowing that Willoughby had the gun.
So you knew that a co-defendant or another individual you were with possessed a weapon, correct?
Sorry?
You knew that a co-defendant that you were with possessed a weapon at the time, right?
Yes.
And when you knew that he possessed a weapon at the time, you took some action to physically assault another individual, is that right?
Yes.
And when you physically assaulted that other individual, is it fair for me to assume that that individual knew that the other individual you were with had a dangerous weapon, a pistol?
I don't think he knew. I'm not too sure.
Mr. Seeger, did you want to ask some clarifying questions?
Sure. So, Mr. Toby, but you did know that he had the weapon, correct?
Yes,
All right. Whether or not the other party knew that he had the weapon, or at least, Your Honor, from my perspective, no, straight that. But you knew that he had a weapon at the time that you effectuated the assault, correct?
yes.
I don't have any further questions, Your Honor.
Well, as a legal matter, Mr. Seeger, how would I determine that there was a felonious assault unless and until I determined that a victim felt threatened by the presence of a weapon?
Well, Your Honor, I think that it can be presumed in as much as the co-defendant pled guilty to it. I was not present for that plea, so I can't specifically what he knew, didn't know, because I didn't have a preliminary examination. I guess it could be presumed, but what he knew or what he's admitting to is that he assisted in a felonious assault wherein somebody was assaulted, wherein at the time he struck another party, and at that time the co-defendant had a fire or a gun in his possession.
Do you agree with Mr. Seeger's analysis that there is a sufficient factual? You're saying you think there is a sufficient factual basis?
Yes, based on that, Your Honor. What the complaining witness knew or didn't know, I don't know if that's entirely relevant.
Mr. Ziegler?
Your Honor, I would agree. I think, I can't recall if Mr. Willoughby pled guilty in front of Your Honor or if it was in front of Judge Mertz, but he did enter a plea to a felonious assault.
I believe it was Judge Mertz, just because I don't have independent recollection of it.
So there was a felonious assault at the same time where the co-defendant pled guilty to it. So there are sufficient facts on the record to establish a felonious assault occurred. There's also sufficient facts to establish from Mr. Toby's testimony today that he provided material aid or encouragement to that assault at that time.
Do the attorneys believe the court has otherwise complied with the court rule regarding the taking of pleas?
Yes, Your Honor.
Yes, sir.
And are either attorney aware of any promises, threats, or inducements not disclosed on the record?
No, Your Honor.
No, sir.
Mr. Toby, after hearing the input from the attorneys, I'm convinced that there is an adequate factual basis to support a finding of your guilt. Further, it's clear to me that your plea is knowing, voluntary, and accurately given. Therefore, I accept your plea and enter it on your record. The next step is you're going to be interviewed by the Department of Corrections. That will result in what's called a pre-sentence investigative report. You'll be back in front of me for sentencing in about 30 days. You need to go over that report very carefully with your attorney. The sentencing hearing will be in person. You'll be here in the courtroom, so will your attorney, and so will the prosecutor. Do you have any questions about that process?
No, sir.
Mr. Seeger, anything further on the record for this case?
No, Your Honor.
Mr. Ziegler?
No, Your Honor.
We're in recess then. Thank you.
I do have a question.
Go ahead.
Would I be able to talk to Mr. Seeger in a breakout room?
Not right now. I have a very busy docket. You can talk to him after these proceedings and in the next 30 days before sentencing.
And I got accepted for the Hyden deal?
You have been preliminarily approved for it because otherwise I would not have taken the plea. But again, ultimately it's up to me. And the only way I'll make that determination is after I review a pre-sentence investigative report, hear from any victims, hear from the prosecutor and your attorney, and hear from you. Once I have all of those items, I'll make my reasoning and my decision clear and plain on the record.
Yes, sir.
Thank you. All right, the court is on the record and calls the matter of people of the state of Michigan versus Charles Robert Dziuba. This is file 23-6610 FH.
The record, Your Honor, Michael, on behalf of the people.
On behalf of Mr. Dziuba.
Thank you. So counsel, lots to go through today. As each of you know, the starting point of our discussion is that each of you is appearing via Zoom. That's obviously not in line with the court's general practice for sentencing hearings, of which this is, but it's because the attorneys made me aware of some certain information that affected whether or not we can proceed today in person to begin with. That information that I was provided started with at some point, I don't know whether it was yesterday or a couple of days ago, information was provided to my staff from either the prosecutor's office or defense counsel or both, suggesting that Mr. Dziuba was lodged in Alpena County and was not, at least at that time, had not posted bond. There was arrangements apparently made for him to be able to appear via Zoom. I had instructed my staff to at least have the attorneys and Mr. Dziuba available to that extent to make a record. Although, as the attorneys again know, generally speaking, I don't have sentencing hearing on felony matters via Zoom. But I at least wanted to allow the attorneys the opportunity to address the court in Mr. Dziuba's presence. However, since I got that information and had my staff make arrangements and let the attorneys know they could appear via Zoom, The clerk's office and my staff gave me additional information. Again, I'm confident it came from either Mr. Rolla or Mr. Brown or both. But that information was that now Mr. Dziuba has posted bond from Alpena County. And the next information that was provided was some sort of suggestion that Mr. Dziuba may be in the hospital. I bring all that information to the attorney's information, and I want to make sure it covered this other information. We are here today for a sentencing, of course, because last month when we had a sentencing scheduled with a prison recommendation for Mr. Dziuba, who's facing sentencing on his 7th and 8th felonies, he failed to appear. He failed to appear, though, despite 3 different circumstances that he brought to the court's attention through his attorney or otherwise. One of those claims is that he tested positive for COVID. One of the claims was that he had a flat tire and he called the clerk's office to report damage. He also called either the clerk's office or my staff and reported damage to his home. Of course, last month was right after the horrific damage that was done from the Otsego County ice storm. And so I was willing, because of that and a claim of COVID diagnosis, to not only adjourn somewhat over to the prosecutor's objection, the prosecutor did object, but also required Mr. Dziuba to show proof of damage to his home, damage to the car tire, and a positive COVID diagnosis, because all of those things were claimed to the court, to various court staff, or to my staff at various points. So we're here again. Mr. Dziuba now, based on the information I have, has been released from Alpena. He's no longer there, and therefore it would be my estimation that he needs to be here today for his sentencing hearing. Mr. Dziuba is not out in the hallway, is he, sir?
No, you're right.
I did not expect that he would be, but I wanted to also make a formal record of that. Mr. Rolla, given all of that background, first, does the court have the background accurate as far as you know?
It does, Judge, but I have some additional information I can provide to the court with the court's permission.
Go ahead.
In addition to the information the court provided, I would advise as follows, that late yesterday afternoon, our office received a call from Ned, who's the probation officer with the Alpena District Court, to advise that Mr. Dziuba was, at the time, had been on probation and was again arrested, his words, picked up for controlled substance, possession of cocaine, less than 25 grams, for which he was charged and sitting in the Alpena County Jail. He advised yesterday afternoon via his message that because of that, Mr. Dziuba, quote, might not be available for sentencing in Otsego County tomorrow morning. After receiving that information, our office immediately took action to try and have a writ prepared so that way we could have Mr. Dziuba available for this court. That writ was prepared, was sent to Alpena County, and Chester at the Alpena County Jail confirmed that they received the writ. They have acknowledged that Mr. Dziuba would be available for Zoom today. However, they also indicated that after being arraigned yesterday sometime, the court set a bond which Mr. Dziuba might be able to post. We later received information that that had been done. And again, it's my understanding Mr. Dziuba is out on bond in Alpena County, but clearly was well aware of his requirements to appear before this court today, either in Zoom if he was still incarcerated in Alpena County, for which arrangements had been made, and if he had posted bond to appear in person. Thank you, Judge.
Mr. Brown, thank you. Mr. Brown, do you believe the court has had the background information correctly stated on the record today?
I do, Your Honor, and for the record, I did receive an email from Mr. Roll outlining that information. I received a text from Mr. Dziuba at 6:54 this morning stating that he was in the hospital waiting to hear from a doctor. That is the extent of the information I have.
Thank you. The court finds it appropriate to take a couple of different orders on the court's own motion. Number one, I'm going to direct the prosecutor's office to prepare a bench warrant for Mr. Dziuba's failure to appear. Moreover, the court's going to create an order revoking bond based upon the backdrop that's been so far brought forth. More specifically, the fact that Mr. Dziuba is on bond, he has requirements under bond to appear at all court dates. I have every reason to believe he had every awareness, not only of last month's hearing date. He has not provided any good cause as required. Number two, he's not appeared today. I have every reason to believe he had knowledge that today's date was here for an in-person hearing. And number three, it appears clear, at least by a preponderance of the evidence, that Mr. Dziuba has violated the terms of his bond by creating, by committing new crimes in Alpena County. On all of those bases, which I'll detail in a written order, the court finds it appropriate to revoke Mr. Dziuba's bond. But I'm also going to ask the prosecutor to prepare that bench warrant so that it can be issued into lien and so that Mr. Dziuba hopefully can be picked up from the hospital or otherwise. I would note that to the extent there's any claim made by Mr. Dziuba to his attorney about a hospitalization, the court finds the same not believable and not credible in any fashion, especially given the circumstances that led me to grant a request to adjourn last month, and then the follow-up information from Mr. Dziuba. Mr. Rolo, will you prepare that bench warrant?
Yes, Your Honor.
And anything further you'd like to say for the record
Not from the people. Thank you.
on behalf of the defense?
No, Your Honor.